Okay, now that most people are sitting down and eating, and I'm noticing that if you're eating, you're really unable to talk with people unless you want to be really impolite. So it's a great time, I think, to start our luncheon conversation. Um, the moderator, or I don't know, the conversant, I don't know how to put this. Steve Calkins, professor at Wayne State University and a Sutherland Fellow at the University College Dublin. Now, you might wonder, is Calkins Irish? I don't really know the answer to that.
And the answer, which I insist on when I'm in Ireland, is that my mother is entirely and very Irish. She had a Roman Catholic Irish father and a fiercely Protestant Northern Irish mother, and they fought their whole damn life.
I never had a chance to ask Steve this question, so I'm glad, and he's wearing a green tie. So he had been not only general counsel of the Federal Trade Commission, he was a commissioner on the equivalent of Ireland's Federal Trade Commission. So this is an unduplicated experience, and so we're delighted to have him as leading this conversation. Tim Wu, well, he does teach at that other school uptown. But other than that, he's a great guy and has written some really important, influential books on antitrust to remind us that the conversation is not all about price equals marginal cost. So I'm going to get out of the way now and let the conversation begin. Thank you, both.
Thank you, Harry. It's a pleasure to be here. Thank you, organizers, all that sort of stuff. Before we got up here, I didn't know that we'd get introduced, and so I was going to introduce Tim, and I read his bio in the materials. It's almost useless, so I went to that learned source, Wikipedia. You all should donate. It's a great cause. I quickly looked him up, and so the answer is that he was a Posner and a Breyer clerk. He's at Columbia. We know that. He invented the term net neutrality, and I don't think he's getting paid for it. He should have come up with some way to monetize it. He's been on multiple lists of the 100 or the 50th most influential people or all that sort of stuff, you name it. In 2014, he ran for lieutenant governor in the great state of New York, and he is a contributing opinion writer for the New York Times. And then finally, and most relevant to this, his fourth and most recent book is The Curse of Business.
Bigness, sorry. Sorry, I didn't mean to interrupt you.
That you can monetize, go for it. So it's a pleasure that we're up here. And I would just like to say that last night when I got here, I saw Steve Salop as I was leaving. Steve invited me to dinner. I had to turn him down, saying, sorry, but I have a 33-year-old son, and I'm having dinner with him, and I am going to meet a significant woman in his life. And Steve said to me in his own sort of self-effacing way, he said, God, your only assignment is don't blow it. Just don't be yourself. Well, today I'm going to be myself, and I've invited Tim to be himself. We have done no rehearsing. I'm allowed to ask any questions that I want, and he can duck them because he used to run for political office. But he doesn't know what questions. This is simply what I'm interested in, and that's what we're going to go through. And so without more, let's get started. You ready?
Great, I sure am, yeah.
All right. First, what the hell happened? Antitrust used to be sort of like Dartmouth College. It was this small little field, and there were those of us who loved it. And suddenly it's a big deal, and it's on all the newspapers and all the politicians, and you have conferences like this. We've got students in our classes. It's a whole new day. What happened?
Well, I think to answer that, you need a little more context because, before it was Dartmouth, it was everything. In other words, antitrust, anyone here who studies even the smallest amount of antitrust history knows that antitrust was this massive national issue in the 19th century, the chief issue in the 1912 election. So in a way, we're back to the future. I want to put it that way. Maybe it's a retro kind of thing, as opposed to the small thing that was a hobby for a couple of people. And why is it back? I think there's a lot of reasons it's back. I think most people in this room know them. There is a growing sense that there's something funny about the economy, a growing sense that many of the features of the Gilded Age have been replicated, whether they are increased concentration across an enormous number of industries, growing inequality, labor unrest, rise in more extreme solutions on the right and the left, whether it's leaning towards socialism, leaning towards authoritarianism, so we seem to be in a rerun, and the classic American answer to the problem of concentrated private power, to the problem of an economy that seemed to betray some of the American ideas of economic liberty, was this war on the trusts and the anti-monopoly movement. And I think what we're seeing right now is a version of a revival, both in academic circles and otherwise, of a classic anti-monopoly movement. And they happen periodically, not just in the 20th century. The American Revolution had aspects of it. The revolt, I'll get even more, the revolt against Charles I had aspects against it. So I just think it's a return back to something that was kind of in sleeping for a while.
In your book, which I'll confess, I didn't prepare in advance. I basically sat down on the plane in Dublin yesterday morning and started reading. And
Well, at least you did read it.
it's a good read. Oh, come on, I marked it all up. Look
Yes,
at all
it's
those
impressive.
tabs. I got it underlined, It's a long ways from Dublin to here, and it's a short book. But you go through, it's a wonderful sort of read through history and time change and all that sort of stuff, and you're going along. And then you come to this big moment and you say, and then things really went off the tracks in a semi-permanent seeming way under the Bush II administration. But then you go on and you say, look at all of these different mergers that took place, and then you, fair play to you, that's an Irish expression, then you say, in truth, most of them were approved during the Obama years, and that's sort of part of what was wrong. And so there my question in ruminating about it was, so what happened during the Obama years where you had a president come in who had talked about antitrust and all of that, and yet things happened that you point to as saying weren't too good, and so what was going on?
Right. Well, that's a good question and a tough question, because obviously I worked in the administration too, so I'm about to criticize some people in this room and also people I worked for. But I think that we did not do what we could have or should have during that administration. Obama did say, when he was in 2008, that he wanted to appoint people who were dedicated to enforcing the law. And I think I like to state it as a case of good intentions gone awry. I think that there was a belief that with the right tinkering, with the consumer welfare standard, with the sort of Areta-style approach, that we could tackle all the problems of competition that we're facing in the economy. And I look back at it and I just don't think we did enough. And why was it? I just think we are, Steve Salop asked a question earlier where he said, hasn't part of the problem been a move towards too much quantification, too much reliance on numbers? And when I was in the FTC, I know people discuss this, I know there's dissent around this, but my feeling was that we were very shy to bring cases where we did not have price harms. We would talk a good game, everyone would sit around and we would spend hours talking about data effects and innovation and quality, all the stuff, but then I got frozen with fear when it came to bringing actual cases that had anything other than a concrete price harm. And I think it, in ways, subtle ways, had sort of, no one would like to admit it, but begun to swallow the central premises of the Chicago school and their ideas that, if you couldn't demonstrate concrete harm in every single case in this quantified way that there was no case there. And, liberals and progressives are also technocrats. They like to believe we're practicing the science. But along that way, we lost something in the spirit of law enforcement, in the spirit of law, which is, to try to find good, strong cases with strong evidence and bring them. And I think there were cases we just should have brought. The mergers are something I focused on in that book. It's hard to defend. I think even when I was in the White House, the people in the White House were like, "What happened here?" I feel that we look back at the end, near the end of the administration. When I was in the White House, we were looking around, and we started doing all these studies about industry concentration and so forth. And people are like, "Well, we kind of blew it." Like one by one, we maybe were technocratically very careful, but in the big picture, we failed to notice what we were letting happen. And, I think that kind of very narrow look blinded us to the broader consequences of what we were building. People were angry about the slow recovery and the accumulation of wealth, the sense that the government wasn't really doing things that were strong and concrete to redistribute the proceeds of the economy. And I think it's led us to the kind of populist divided politics that in fact contributed in some way. I don't want to blame antitrust for the current administration, but I think that we did not do enough for the middle classes during those years, and that we need to realize that extremism comes when the middle classes don't think they're being looked out for economically.
For those who don't know, during the Obama administration, what was your position or role, or what were you?
So I was in the Federal Trade Commission in some kind of strange special advisor role, where I joined a bunch of cases, and then I was in the White House at the very, very end, National Economic Council.
All right, good enough. There was discussion earlier today about Instagram.
Yes.
And that acquisition, and as we heard it described, it was just 11 people, and it wasn't doing a hell of a lot, and it wasn't planning to do exciting things, and so you could understand, we were told, why there wouldn't be a challenge against it, right? That kind of thing. What's your take on why that merger went through, and if you were to second guess it, why would you second guess that
Yeah,
decision?
I'm happy to second guess it. I can have some sympathy for the position of the people. The arguments, the lawyering was strong, but I think it was a mistake. I think it's important, I'm criticizing the administration I worked in, that we acknowledge times that even though things seemed, we got to be able to call out our own mistakes. And Instagram, I think, is an example, particularly when you Instagram and when you add to it the fact that we let Facebook overall defend its position with 97 unchallenged mergers, that we had to look back at that and say, okay, maybe every single one there was problems with each, but did we just really allow a social media monopolist to defend its position in straightforward violation of what the Sherman Act is supposed to allow? And I think the answer is yes. Now, if I focus in Instagram in particular, I think it's important to look at circumstances 2012. So Facebook had achieved dominance in early social networking, but they were vulnerable. They were vulnerable in two respects. First, they had a great weakness in mobile. They didn't have a good mobile product. Second, they were starting to suffer from demographic shifts. Parents started joining Facebook, and so they were no longer, there was a talk in the Valley, they were no longer the thing. And the narrative at that point, sort of the myth of Silicon Valley at the time is that, no company can last more than 5 years, maybe by 8 years, they're basically headed for obsolescence. And, this was supposed to be a kind of a Valhalla of open competition. And in the narrative to that point, there had been a lot of replacement. AOL went away, MySpace replaced by Facebook, and it looked like the same thing was that everyone saw Instagram rising. They had 40 million users. They didn't have a lot of, they had a faster growth than Facebook itself. They had enormous amounts of venture capital funding. They were being pursued by Twitter. So Twitter had the interest of turning Instagram into a Facebook killer. And you put it all together, and, looks at, and then finally you have documents, which have been reported on, indicating a predatory intent. We need to get this company because they're they're a competitor. This is dangerous to us. So you add that together, you might think even a condition on the merger maybe, but just to completely just like, oh, that's fine, let's let it go. That's craziness. And, when you look back at the analysis, the FTC analysis is hidden, but the UK office released its analysis, and in retrospect, it's kind of embarrassing in the sense that they look and they say, well, Facebook hadn't really developed a photo app that was any good, so there you go. And on the other side of the market, Instagram had not yet started to sell advertising, so really this is not a competitor at all. I think someone mentioned earlier attention markets. I think, first of all, it's very clear they're already competing for attention. Facebook understood this. They had the 40 million users. They were the most dangerous thing in the market. And second of all, the idea that they were just obviously about to come into advertising. It wouldn't have taken any stretches, but something, the potential competition doctrine is a terrifying thing, I think, for a lot of staff attorneys because it always leads to losing. So it's a little bit of a mental trap. And, I think we got to admit we blew it. And what I think confounds it, this is something that was said on the previous panel, was, okay, so they got away with that one. And then Facebook just kept buying its most dangerous competitors. WhatsApp was the next target. And, okay, so maybe Instagram's forgivable for, okay, maybe it's not a big deal. But then you get their next most dangerous competitive threat, the next. And you have to feel that was, in retrospect, nothing short of allowing the defense of a successful monopoly and therefore a failure.
I can't resist asking whether, after the coronavirus does God's work and we end up with a Democratic president.
You
less
said
than a
that,
year
not
from
me.
now, and you're appointed chair of the FTC. Would you be inclined to go and bring a now post-acquisition challenge against Facebook for Instagram?
I would be so inclined.
I mean, you would look at the facts, I'm sure, and you do all that good stuff, but what's your inclination?
I would be so inclined. I think that retrospective merger analysis, whether through Section 2 or Section 7, but particularly through Section 2, I think is the right lens to think about it. I think it's an important case to look at. I haven't seen all the documents, but you got to start somewhere. And it strikes me that the arguments that there would be some terrible thing if we broke up Facebook into or required it to undo some of these mergers. I don't. They wouldn't like it. But the argument that this is going to be the end of, the end of our opportunities to compete with China, or I just think it's a relatively, in some ways, straightforward way to reestablish the primacy of the rule that you just don't buy your competitors as a way of dealing with threats to monopoly. And so, yes, I think it's a good case.
I can already read the Wall Street Journal editorial page saying that, oh my God, the world's going to come to an end. Every acquisition now is going to result in the CEO sitting around and failing to integrate and try to promote and do better stuff because they'll be worried about the rogue FTC coming after them to undo it, and we'll lose all the benefits of mergers because everybody will be so scared about post-acquisition challenges. Oh my God, oh my God, oh my God.
That seems to me like a feature, not a bug. In other words, if the incentive... If you're worried that, well, if I buy this other hospital and we raise our prices, the FTC might come after us later, that seems to me like a pretty good thing. In other words, if the disciplining effect is to avoid egregiously anti-competitive conduct, think about the AT&T Time Warner merger is a good example of that. Where no longer, almost as soon as the ink and the judgment had dried, they start using HBO to bludgeon Dish into submission. Not 5 months after the merger. Now, if they had this credible threat of a retroactive challenge, where everyone would have to admit the facts are going to be a lot clearer. Imagine if we challenged AT&T Time Warner merger now, what would the facts be? Well, Dish, HBO would be the facts. That would be the centerpiece. There's a lot of disadvantages in doing everything in a forward, predictive sense. I think it's led us to bless many mergers we shouldn't. And the balance to me, there's obviously Sun done retrospectively, Whole Foods is an example, but I think there would be a healthier set of incentives if there was some fear that if you acted in egregiously anti-competitive ways after merger, that you'd have either the FTC or Justice Department taking a look at what you're doing, that would actually be a good thing.
Let's go back to the book. So I'm reading here on page 135. Let's see, and there's a reference to, quote, the absurd and exaggerated premise that, single quote, Congress designed the Sherman Act as a consumer welfare prescription, close quote. Indeed,
Right.
you quote that line at least twice, maybe 3 times in here. And so I then, of course, the book conveniently did not have footnotes, so, but thanks to the wonder of the internet, you can look these things up. And that line comes from Writer v. Sonotone, a 9-0 win for consumers, where the Court of Appeals had said consumers can't bring an action, only businesses can be injured in their business or property under the Clayton Act Section 4, and consumers can't. And then the Solicitor General under Democrats, Wade McCree and John Shenefield, admittedly, Frank Easterbrook was in there too, went to the Supreme Court with an amicus saying it's important to let consumers be able to sue too, and the Supreme Court 9-0 ringingly in a pro-consumer case wrote that it's a consumer welfare prescription, start the violins playing, and yet you obviously don't like that.
Well, let's be a little more careful what I like or don't like. I have no problem with that decision. I have the problem with the elevation of the idea that the elevation of consumer welfare as into the only goal of the Sherman Act or the other antitrust laws, which becomes even less plausible, is, to my mind, as I said, not correct, absurd, inconsistent with the original intent of Congress. There was a famous paper written by Robert Bork claiming that Congress had so intended, but I'll rely on the authority of Herbert Hoppenkamp. Any other, no one who's looked at legislative history has been able to find that. What they find instead is a Congress that we're talking about the Sherman Act Congress, concerned about the power of monopoly, concerned about the political ramifications of corruption of the legislature, concerned about small business, concerned about labor. They make Bernie Sanders look like a moderate. When you look back at the Sherman, I'm not kidding. It's an angry period. So Clayton Act legislative history is anything more extreme. So these are Congresses who are not concerned with this one question about prices or narrow thing consumer welfare. That said, it's not like I am a consumer. I like consumers. I think consumer welfare is very important. I just think that it's a legal error we've made, and we shouldn't stick with that legal error if we want to be faithful to the intent of Congress. What I tend to think about the consumer welfare movement is I think of it as, in some ways, a noble undertaking that went too far. So, there's progressives, a lot of people in this room are sort of technocratically oriented. Something beautiful about the science of being able to measure with precision what a law should do. But there are so many things that are so hard to measure that matter so much for any kind of antitrust case of significance. Dynamic effects, very hard to measure, quality effects, innovation effects. And those are just even within the economic paradigm. We also have, as Learned Hand said in Alcoa, we have this clear statement of interest in non-economic concerns, the political concerns, concerns of concentrated private power. And let me end that, as I think that, we've seen over the last 8 years, I think some of the current political anger and sense of what's going on with the economy has to do with this idea that we maybe fetishize the consumer too strongly. Because, in our lives, we are all consumers, but we're also employees or workers or producers. People are a lot of things. And, the enterprise of trying to hope we can get everything right in these sort of microeconomics by focusing on this one question of making stuff cheap, which I like cheap stuff too. But to say everything is captured by that is a gross exaggeration, I think, that has led us astray. And I believe we're in the beginning of trying to overcome that. Now, I have allies who are trying to sort of redo consumer welfare, do a better job, and I think that's worth it. But I do think we need to push against the concept itself and ask whether it's doing what we need to have an antitrust law that serves the purposes that it was intended to serve.
Okay, a couple of things. One is that if you say that a Borkian consumer welfare is too narrow because it was looking at total welfare and you say that was a mistake, so you then circle back and say we're going to look at actual consumer welfare for the welfare of consumers. And then you would note that, of course, this in no way says that it won't let you challenge a monopsony case because we don't, by the term consumer welfare, mean it can't be going up or going down. And you then note that consumer welfare, there's no reason that that can't include quality kinds of considerations and innovation kinds of considerations and long-term, lots of different things. Then you come back and you say, okay, what is not, if we would agree with that, and you could then debate whether or not to say you need a rebranding or not, right? But but that's still a limited, it's still a controlled set of things one is looking at, right? What does that, if you will, real consumer welfare or thoughtful consumer welfare, what does that not cover that ought to be covered by a judge deciding a case?
Well, it's a good question. Well, one thing I think is frankly a branding problem, is I think that, despite what we say in this room, despite what people talk about when we hang out at the FTC or in academia about the sort of broad and enlightened version of consumer welfare, brands matter. And I think that in the judicial imagination and also in a lot of enforcers, it's overly associated with a burden of proof on the plaintiff to demonstrate lower prices. And even you can say that, we don't really think we're more creative. I think it has that association in a way that is a little hard to shake. I am personally, so I think you can get almost anything you want, but I still think there's that brand problem. That's something Carl Shapiro said as well, is it's sort of gotten this problem of being...
I can't resist saying that at a speech I gave at the AAI, I suggested fixing the brand by calling it competition welfare. So I can understand the branding issue, and I think Carl's got a sensible point. So go ahead.
I think also that there's a couple things that you get close, but I think it doesn't. I prefer. The older protection of the competitive process standard, which, it doesn't seem that different. In fact, a lot of cases use it. Microsoft, in fact, when you really look carefully at Microsoft, it doesn't really use the consumer welfare standard. It uses the competitive process standard. And, they never prove, actually, that prices are going up for someone. There's a little paragraph where they say, but of course this hurts consumers. But, the assumption, I think we need to be able to win cases like Microsoft in government. And I think that a hardcore version of consumer welfare, if you demanded quantification, it's not clear you would actually get there. What I think is the advantage of thinking hard about the competitive process is this. The way cases, there is this thing called the competitive process, and it's out there, it's ongoing. And when a case comes in, the question in the enforcer's mind, I think, should be, is this an undue, unwarranted interference with the competitive process or not? And I don't know if, and I think that in some ways is an appropriate stopping point, especially for exclusion cases. I mean, one thing I think consumer welfare has never done well with is this enormous branch of antitrust called exclusion, right? Because exclusion cases, what they do, they knock out a competitor, and then you have to sort of somehow figure out how that maybe result in less choice the consumer goes through, but it's actually just more obviously harmed the competitive process. If you, let's say Allied Tube, take a case like that, you knock out plastic tubing in favor of steel tubing, you have interfered with the competitive process. That's more naturally what I think we are, that's an easier way to think about it. It puts both the judge and the enforcement agencies in something more like a position like a sports refugee, which is there is a sort of natural course of play, and then there are sort of fouls or deviations that go too far. It matches up a little bit with Section 5 unfair competition standard, things that go too far. And you notice in a sports competition, let's say football, you don't have to prove in every for every penalty that, but for this penalty, it would have, the person would have, but for the holding, there would have been a different outcome, or you don't have to prove that the fans were their welfare was decreased by the foul or something like that. I mean, then you wouldn't have no calling of fouls. And sometimes I think we almost get to that point where we have, you're actually supposed to prove, okay, you did this, but did the fans care, or can we actually prove, even though we know it's a foul? And so I think antitrust should, it seems weird to say learn more from sports, but I do think this focus on the competitive process, which inside the agency is often what it is in the back of people's heads, should be moved to the front. And we should say, well, take that Facebook, Instagram. When Facebook acquired its major competitors, one after another, a serial acquisition campaign, was that an interference with what we imagine as the competitive process? When Microsoft knocked out Netscape as its most dangerous competitor. And that's a very different kind of way of thinking about it than consumer welfare. And I think much more suited to the way, in fact, the economy works.
In your book, you seem to be fairly mellow with the shift away from the old days of aggressive vertical restraint enforcement and with that sort of thing. And so I'm playing out in my head, let's assume that we announce a new standard, competitive process. Doesn't that run the risk that then you start rethinking all the areas of the law that are now pretty well settled in a way that you seem to be comfortable with, and most people who would be in that progressive camp, if you will, would be comfortable with, and everything has to be rethought if we're saying this really is a new and a different standard?
No, I don't think so. I don't know if things are settled as much as moved to this nebulous realm of rule of reason. You know what I mean? Well, that's the standard, I agree, but it moves you, doesn't mean you've settled or accepted that vertical restraints are always justified. Yes, as you say in the book, among the things I'm relatively mellow about is I could bring myself to defend several things, but not the per se rules against various vertical agreements. So that isn't a direction I went in. And no, I don't think so. I think the vertical restraint, I think a competitive process standard would once again lead us in a better direction in understanding some of the harms if they're caused by a vertical restraint. So if you have vertical, I think the analysis would be back to I think goes back to Chicago Board of Trade. Is this the kind of restraint that tends to promote the competitive process or tends to destroy it or inhibit it? And I think that's basically the question you're asking in a rule of reason vertical case anyways, or it's a question you should be asking, and that's where I'd leave it.
You do say good things about Chicago Board of Trade. And I must say that when I think about the Chicago Board of Trade and the rule of reason, I think of that long list of every damn thing you're supposed to think about in analyzing something that tells you almost nothing. And indeed, I think I've mocked it as the full Monty approach to analysis kind of thing. And then you go back and you're reading parts of the opinion that seems to say restraints are justified if they could mean shorter hours for the workers or whatever. They're just all these different things that don't sound in antitrust. And gosh, do you really want to go there?
Yes, I do.
It's not rehearsed, folks.
No, I do, and I'll pick up on American Express as an example. I mean, I am in a book which has stolen a title from Brandeis. It'd be hard for me to criticize Chicago Board of Trade. I should say that it's a sort of a book that represents Brandeis's view. And yes, I am willing to go there. I would what you describe as a whole bunch of things and I also described as lawyering, I'd say, and I want to point. There's two contesting traditions in antitrust. So the lawyerly tradition and the more econometric tradition. And in some ways, I'm calling for return to the. This reflects some of the Breyer influence, as opposed to Posner. That the deep dive into facts to figure out what was going on in this industry and what was happening. I think that's what Brandeis believed in. And if you look like a case like the American Express case, the Justice Department did a terrific job there trying to figure out how are these exclusionary rules actually doing? What are they doing? They have a very strong case that they were harming competition in the industry, interfering with the competitive process. I mean, it was kind of straightforward. And in fact, the Supreme Court opinion to me is like a new version of the old per se rules. It's sort of a plaintiff loses automatically rule because of this thing we don't really understand, but my law clerk wrote something about it. we're actually in a generation where the things have changed, where the people who want to enforce antitrust are more interested in something like rule of reason, while cases like American Express reflect a mirror image of the old per se rules. It's just that the defendant always wins instead of the plaintiff.
I think on behalf of the defense part of the world, is very happy to have the rule of reason, because the rule of reason is defined as the defendant always wins. It's really a beautiful world, and I don't think they want to get away from it. But I'm glad you mentioned the court, because you were part of issuing something called a Utah, where are we? The Utah Statement Reviving Anti-Monopoly Traditions, the area of big tech that you did, which was to come forward and say, okay, what do you really mean? And you said, okay, we'll try to put out what we really mean. And this is in your materials, so if you want to read it, you can. But so I'm looking at the thing and what you would change in doctrine. And you go forward and you say, okay, you would overrule, Trinco, Brook Group, Weyerhaeuser, Linkline, and then Knorr and Pennington. And so I go back and I look at those, and Trinco was 6-0 with some concurrences. Brook Group was 6-3. Weyerhaeuser was 9-0. Linkline was 5-0 with 4 concurrences. Knorr and Pennington were each 9-0. And I then did another quick check, and the court is now more conservative and younger than it was there, with 5 conservative justices. The only 2 over 80 are both Democrats, one being Breyer. So that's not going to change. And then you go and you look and you discover that in the courts of appeals, President Trump has appointed 29% of the Court of Appeals judges, and overall Republicans have appointed 55% of the Court of Appeals judges. And so is any of this going anywhere?
You seem to have forgotten that there's more than one entity capable of overruling the Supreme Court. In other words, Congress can do everything I just said if it wanted. And also, I'd say that small things have big things have small beginnings. When Bork wrote his work in the 1960s, as Posner later said, he was considered the lunatic fringe. The idea of overruling, the half dozen cases they named was seen as unthinkable and kind of like a bad joke. It did take 20 years or so, but in the end, more or less, the errand director Bork line as to what cases should be overruled came to rule the roost. And so I believe it's important to put out what you think your positions are, and I believe that over time, if every one of those decisions is modified or whatever, I don't know, but I think some of them in their core do not stand up well, and we will come to understand that and overrule them either congressionally or by the courts.
Let me go a different way. Still going to the Utah statement, you say that there should be the Clayton Act's exemption should be extended to all who labor for a living regardless of statutory employment status, yada, yada, yada. And I remember when I was with Pitofsky at the FTC, we did have a bunch of people who were out there working for a living who wanted to be exempt from the antitrust laws, and they managed to lobby Congress. And indeed, physicians seem to have done pretty well at getting attempted at an exemption. When you look at the enforcement records against people who work, you will find that there was an FTC case against the AMA. There was an Indiana Federation of Dentists case, a Superior Court trial lawyers case, a Justice Department National Society of Professional Engineers. Would you make all of those people exempt from the antitrust laws too, or are you using labor to mean manual labor or something? I don't know.
I think that the antitrust laws and labor have a long history, sometimes very difficult history. They are in some tension. The idea of organization is, the idea of labor, unions at all, is premised on this idea of an imbalance in market power to begin with. So it has an economic basis. So, I don't have any precise answer to which groups should or shouldn't be immunized, but I do believe that the basic tenet that you need to have some kind of way to deal with the inherent imbalance between employer and employee power, remains true. And when the antitrust laws conflict with that idea or are interpreted to conflict with that, that can create problems. I think this is a really, when I was in law school, labor law seemed like, I think like 5 people took it. The challenge of labor, like this is good for younger people to go in this area, to go into either labor law or the antitrust scrutiny of labor-related issues. It is the time, because we need to figure out new answers. If you look at the fact the economy, only in recent years is a marginal increases in household income. For 30 years of flat incomes for most Americans, something's not quite right with the economic system. This sort of transcends antitrust. And all I'm saying is antitrust should not get in the way of the development of some solutions to the problem of labor.
We are starting to run out of time, so let me give you one last question, which is the question that actually everybody in the whole room really wants me to ask, taking advantage of the fact that I can ask whatever I want. How does one become a contributing opinion writer for the New York Times, and what does it pay?
The second kind of question is the one my Asian relatives ask me all the time. It's kind of, in Taiwan at least, where my father's from, they just ask you, like, "You're a professor, how much you make?" I'm like, "Thanks." It pays better than blogging. How's that? And how do you?
He used to be a politician.
Believe it or not, I've had a long sideline working as a journalist in one way or another. I started writing for Slate a long time ago. So it actually wasn't this like someone came up to me. I sort of slowly had been building up a portfolio of writing, and so it was. I'd like to think it wasn't. I put some work into it, I guess. I wrote for the New Yorker for a while before then, before the New York Times. So I was sort of making my way up. How's that?
Yeah, pretty good. I like it. You've been very, very good at humoring me. Is there anything that you want to ask me? It's only fair to have a little bit of turnaround.
Well, I guess the obvious question I asked you is like, did you like the book? You do put the notes on it.
Yeah, let me tell you. What's good about this book? One is that it's a quick, breezy read. You can finish it in less than half the Atlantic Ocean. But then it's got all sorts of things that are sort of nifty. Here you go. One thing I like is an opening sentence to a paragraph. Ready? Once upon a time in the 1990s and 2000s, the web and the internet were new and everything was going to be different forever. And I just love that sort of image out there. But there's more that is along that lines of there was a different era. One of the things that you reminded me of that I had forgotten was that you talked with great enthusiasm about the role that presidents played in influencing enforcement decisions by an antitrust division, singing the praises of Teddy Roosevelt with the trust busting of Richard Nixon and AT&T. And I was fast forwarding to today and wondering sort of, where are we and was that a different era and so on and so forth. So that was nifty, I thought. This is the first time that I've read in any book a real almost sort of appreciation of the important historical role of Leon Czolgosz, the man who killed William McKinley and gave us TR. But I've never seen his name actually in print before, so that was sort of fun. It was interesting. You've got a nice little chart that shows what you mean by the curse of bigness,
Yes, I do.
which, to the surprise of most people in this room, begins being talking about the inefficiency and the diseconomies of scale and the curse of bigness almost from the management perspective. So that was interesting. I like the fact that you gave a shout out to the UK Market Investigations, which I think is a resource that we should bring to America. And I've said that before, and I'm glad to have that. And then the thing that I like best, and I'm going to close with this, this was something that I hadn't known about, but I'm going to end with this reading from this. We're talking here again, you're talking about Brandeis and how wonderful he was in spite of the absurdity of parts of the Chicago Board of Trade. That was me. But on you go, and you nicely put in a footnote saying it wasn't all roses and that
Right.
he had a prickly side to him. And the thing that I really love, given that I've always thought that Learned Hand was one of the great people in the history of the world, this little comment from Justice Learned Hand recalls his meetings with Brandeis this way, quote, "I used to leave him, Brandeis, feeling of myself, quote, you are a self-indulgent, inadequate person. You sit around and talk a good deal, haven't any very definite convictions. You like to drink too much." And I just think the better of Learned Hand because of that. And
Can I say one last thing about this book?
Sure.
Which is, this is on the edge of being an advertisement, but I wrote an international version. You can't write to, Americans want to hear about America, and the rest of the world gets sick of America. So there's an international version of this book that is being released for our European friends in May. And I also wrote an academic supplement to this book, if anyone is interested, which covers the 1930s. I deleted it for the general audience because it was just getting too long for my little book on bigness. But I have a whole book about the 30s and 40s, and a free supplement on the 30s and 40s, should anyone be thinking of assigning this book at any time. All right, thanks so much.
thank you, Tim.
Appreciate the question.